Although the complaint before the tribunal was successful, it was overturned by the Superior Court of British Columbia, and that judgment overturning it was upheld by majority of the Court of Appeal of British Columbia. Could you explain what their reasoning was and the basis of the Supreme Court of Canada rejecting such reasoning?
Section 8 of the British Columbia Human Rights Code, and many codes contain similar wording, refers to the obligation of a service provider providing service that is generally made available to the public and to be done free of discrimination. The tribunal found that Jeffrey was discriminated against both by the province and the school division by not being provided with the services effectively programmed for his dyslexia, resulting in his inability to optimize the education services being provided to all other children. Now, the Superior Court and the majority of the Court of Appeal found that in order to determine whether he was discriminated against, he should be compared to other children with special needs. They found that this comparison showed that he received no less service than such other children, and therefore he was not discriminated against. Well, this is an incredibly important part of the judgment. Comparing Jeffrey with other special needs students and showing that he was treated no worse than those students meant that this district could cut all special needs programs and yet still be immune from a claim of discrimination, no matter how badly special needs students had been treated. In other words, if you treat them all badly, then that seems to be justified according to their reasoning. However, Justice Abella in the Supreme Court of Canada went on to note that if Jeffrey was compared only to other special needs students, full consideration could not be given to whether he had genuine access to the education that all students in British Columbia were entitled to receive.